And then I think we can start. There are one or two that are still going to join, but I don't want to hold you all up for that. So a very warm welcome to everybody. Thank you for choosing to share this hour with us. This is the next in our series of lunchtime webinars that the Society is offering for its members and for others that are interested. So a very warm welcome to those of you who are members of the Society, and those of you that aren't, we hope to induce you in due course to join us. We thought for today we would talk a little bit about what happens before and after a mediation. So a lot of time is spent on the mediation process, and I think by now most of you are familiar with the process and are in fact using it. So we thought we'd focus today and spend a little time on before the mediation and after the mediation. So I'm just going to share my screen. And we can start. So as I said, the focus is on before and after the mediation. So before we get into that, I think it's often important for us to take a step back. I think we work a lot of time on assumptions and kind of think we've got a handle on things, but it's important now and again just to go back to basics and think about what we are actually dealing with in the mediation space. And I really like this definition of conflict, because I think we very rarely go back to kind of thinking, what is it that we're dealing with when we're going into this space? We're dealing with conflict. And this definition for me captures it very nicely, that conflict is a state of tension that exists between two or more parties when needs, expectations, or wants are not being met. And there's quite a lot to that definition. So it's a state of tension between two or more people, and it's simply that. In a lot of conflict kind of management training, participants are asked to kind of shout out the first thing that comes to their mind when they think of conflict, and a lot of those responses are often negative. It's anger, frustration, disappointment, and conflict itself is actually neutral. It's just that state of tension, and it's how we deal with it that determines the trajectory for that conflict and kind of what attributes get given to it then along the way. So it's a state of tension that's neutral, and that state of tension exists when needs, expectations, or wants are not being met. And if we focus on that definition in the mediation space, when we're looking for a mutually acceptable outcome, quite obviously, what we need to do is look at why those needs, expectations, or wants are not being met and how we can achieve some kind of movement towards meeting them. Quite simple. I think we overcomplicate it a lot of the time. So if we understand conflict to be just that state of tension, then mediation is structured, facilitated negotiation with a view to finding a mutually acceptable outcome to resolve that conflict. And I think if we take that step back and appreciate what we're dealing with as we enter this space, it goes a long way to tempering our approach in that space. So again, when we're going into this space, our focus is settlement. And so as mediators and as representatives or parties in the mediation, we need to reorientate our approach. It needs to be constructive, and the aim is to facilitate collaborative problem solving. So as a mediator, that is your responsibility. It's to hold that space and create a space that can facilitate collaboration. And if you're a representative bringing a party into a mediation space, your duty or your role is to help your client facilitate that collaboration. So it's a lot of adjusting an approach, and a very important kind of pre-step to mediation is making sure that the mindset, the approach, and the manner are all conducive to what you're trying to achieve. I thought this slide would be helpful as well, because these are the kinds of things that when you are representing parties in a mediation space, you should be displaying. So it's things like emotional intelligence, being alive to cues and subtleties coming from the other side, exceptional listening skills, as we know. Sorry, there's just someone trying to come in here. Exceptional listening skills, as we know, a lot of what mediation is about is actually not presenting your case. It's listening very carefully to what's being said by the other side, because that will give you insight into what they're looking for. Your approach also then shifts to strategic questioning as opposed to cross-examination. So trying to distill information from the other side using very strategic and well thought out questions. An authentic display of empathy and humanity, trustworthiness, preparation, flexibility, creativity, and patience. And when you look at those kind of attributes, ask yourselves how many litigators you know that have those attributes. And if you are a litigator, you'll be well advised to shift your approach and to enter the space with these kinds of, oh, my apologies, skills. Because there's so few of us, please feel free to stop me at any stage if you want to ask questions. So as I said before when we started, the focus of the session is looking at what happens before the mediation and then what happens after. So we've given a little bit of context about the space that we're entering. Before the mediation, the most important thing is preparation, preparation, preparation. A lot of people assume you can do mediation on the fly. They think it's simple. They think it's literally about showing up on the day and seeing how much they can get for their client. Mohammed, you have a question.
Hi, Michelle. Thank you. I just wanted to inquire on your side, what would you suggest I know we all have our own preparation, methods and things like that. And each of us have our own way of preparing. Now, assuming that we are doing a in-person mediation, what would you say generally the ideal preparation would be? So as you have before the mediation, prepare, and then client case and mediator. Maybe, just to touch on how you suggest we go about preparing.
Thank you, Mohammed. So the next kind of part of the presentation is all about that. I'm going to unpack each of these three silos: how to prepare your client, how to prepare your case, and how to prepare the mediator. And I want to suggest that if you don't prepare, you're missing a huge opportunity. And I'll tell you why. So the first one is about preparing your client. So bearing in mind all the things I've said about the mindset and what's important going into the space and being focused on kind of a collaborative approach, it's important firstly that your client is appropriately advised so that they know where they stand legally. And this advice will come from you as representative kind of before the mediation and during the mediation. You need to explain the process to your client so they understand what to expect, that they understand that you're not entering a litigious space that everybody is aware of and comfortable with because they understand it. This is a very different space, so they need to understand how it's going to work. Important for you to assess the risk with your client, the probabilities if they run the litigious process and where they're likely to end up. the risk of not settling, the risk of settling at maybe something that they didn't want, perhaps, but when compared to running the matter as a trial, kind of where all that risk sits. Then it's important to manage the expectations. And whilst what I'm saying now is relevant to a representative preparing the client, a mediator also needs to be cognizant of all of this and even coach the representatives before they come to the mediation on the kinds of things they should be doing to making the mediation effective. And managing expectations is a very important one, especially if you're already in a litigious process and you're expecting certain outcomes. Then reorientate your client to collaborative problem solving, what that looks like. Perhaps start throwing around possible solutions with your client, just so that they can start to think about how this can resolve. Those of you who have done mediation training, formulate a ZOPA with your client, zone of potential agreement. So find out where the parameters are for settlement. Never a good idea to kind of formulate an ideal solution. There must be parameters, and so it gives you some movement to work with in the mediation. And then think about how and by whom the case should be presented. So strategically consider your client, consider the other side, consider the nature of the issues between the parties and what you think would be more effective in the mediation, whether your client should present or whether you should do that. So a couple of things to consider with a client, and as I said, even as a mediator, maybe before the mediation, if there are representatives involved, just suggest to them that these are some of the things that they can do before coming to the mediation. Then you need to look at preparing your case. And preparing your case for a mediation is very different to preparing your case for court, obviously. And what you need to consider is what is important for the mediation, what is relevant for the mediation. So what the issues are between the parties and what the facts are, or the background facts are that support kind of what the issues are and will orientate the mediator. And then following on from that, what documents you need to bring with you to the mediation to support your case. So all of this needs to be considered, and a very strategic approach taken to distilling the issues and formulating them in a way that is conducive to collaborative problem solving. Once you've done all that, you can start to prepare or thinking about the opening statement and the approach that you're going to take to kickstart the mediation. So that opening statement is one of the most important steps in the mediation. And again, as a mediator, perhaps some thought should go into working with the parties a little bit before, to giving some thought to their opening statement. Who's going to give it? Is it going to be the representative or the client, and what you're going to say? Because that opening statement sets the tone for the day. A lot of the time, parties are coming into this mediation space very nervous, very apprehensive. A lot of the time, they haven't engaged with the other side for a while. It's all been through attorneys. And so the opening statement can go a long way to setting the tone and giving a clear indication to the other side that it's all okay. We're here all on the same page. We're here to try and find a solution. And that needs to come across. An opening statement can do the opposite. It can do a lot of damage if you come on saying, we've got a good case, we're confident that we can win, and you start kind of trying to persuade the other side that you're right. That's counterproductive. So a lot of thought needs to go into that opening statement and what you want to achieve that day through that beginning. And then you need to prepare the mediator. And a lot of people miss this opportunity as well. So some mediators ask for a kind of a mediation brief or a mediation statement that's sent to the mediator beforehand, just to orientate the mediator to the issues. And again, if you're a representative, this is an opportunity to put forward your case and what your client's needs and wants are before you start. So that mediation brief can either be confidential, in other words, just sent to the mediator, or it can be shared with the other side. My preference is that it's shared. I think it's a missed opportunity if you don't share it, because it's an opportunity to just indicate to the other side and to get an indication from the other side what they're thinking and what their approach is to the mediation itself. So the opportunity in that mediation brief is also to manage the expectations of the other side. So yeah, so think about that, and I would recommend that it's shared between the parties. So in the brief, you're going to put your factual background. So when you've prepared your case and you've distilled the issues and the facts that are relevant, put that into the mediation brief. Case law can be included. A good strategy can be, if there is a case that's detrimental to your client, to acknowledge that perhaps, and limit the parameters of, or the damage that you think it causes, just to again manage their expectations. If they think that they've got that as a trump card, say, you know, we know about that. We don't think it's that serious for whatever reasons. And then if there are any cases that are strongly in your favor, put that in as well, because that kind of gives the other side an idea of your thinking about the matter. Be very, very careful, like in the opening statement, of your tone. In a mediation brief, because it's a written document, the temptation is to draft heads of argument or to try and be persuasive. That's not the purpose of the mediation brief. It's really just to orientate the mediator and the other side to what you are thinking about your matter. Remember, the mediation is not about being right. So again, don't try to persuade. You're not trying to persuade anybody that you're right. In fact, the only thing, and this is a good thing to tell your clients and the mediator to tell the parties, the only thing you actually need to agree on is the outcome. Nothing else needs to be agreed between you. And once that's kind of said, it almost relieves the parties of having time to try and persuade. Hilton?
Hi, Michelle. How would the mediation brief differ from the opening statement? Obviously, one is written and the other is delivered verbally in the mediation. What would be the essential differences? Obviously, there's an overlap. There would be an overlap.
Sure. So the mediation brief, probably more comprehensive, because you're setting out background, facts and context, attaching supporting documents if you want to, really just orientating the mediator on the history of the matter and what's brought you to this point. The opening statement, probably more focused on what you want to achieve on the day. So I would say the opening statement is your opportunity then to really just give the other side an indication of your approach and what you're seeking to achieve. I also often ask the parties in the opening statements to maybe just say one or two things about why they've chosen mediation and what they're hoping to achieve that day, just to kind of set the tone for the day. So I think perhaps the mediation brief more factual, more contextual, to lay the foundation, and then the opening statement really focused on the day and what you want to achieve.
Thanks, Michelle.
Pleasure. And then the last thing in the mediation brief is maybe suggestions on how you think the case can be solved. So for that aspect, you would cover if there's something your client absolutely needs to have. Is your solution a payment? Is it an agreement to do business in future? You know, what are you looking for? Also, really importantly, set the tone for the day. So that's really looking at before the mediation. Preparation is key. A lot of thinking about the matter, a lot of thinking about what your client wants, and then how you're going to achieve that. Does that answer your question?
Yes, it does. Thank you.
Okay. So then let's shift to after the mediation. So you've done the opening statements, you've run the mediation process, and now you are at the end. The mediation can end in a number of ways. Yes, Ishara.
Sorry, Michelle, thank you. I just, before you move on, I just wanted to get your opinion whether it's prudent for the mediator to reach out to the parties and explain to them what how to prepare, and also what should go into the briefing document and the opening statement, because I've had a lot of instances where there is no pre-mediation meeting between the mediator and the parties, and so when we start the mediation and the opening statements are being delivered, they're all over the place, and I find myself needing to contain it and then guide them at the mediation on, you know, what is irrelevant or irrelevant, or, and sometimes these things, the opening statements can go on for like 20 minutes. So how do we manage that?
100% agree with you, Ishara, and it's a, you know, when parties are just coming to the mediation and starting their opening statements from scratch, a lot of the time they're trying to persuade you. So what I do is, in my agreement to mediate, one of the steps before the mediation starts is that they need to both provide me with a mediation statement, and what they're hoping to achieve and how they see this being resolved, and then the pre-mediation meeting. So I didn't touch on that, and thank you for bringing it up. But so in my agreement to mediate, I say that a few days before the mediation, they need to file the mediation statements, and then we have the pre-mediation meeting. And in that meeting, you can deal then with opening statements, what's expected, the mindset that they need to bring with them, and what the approach should be. Explaining that they're not trying to persuade you, that, you know, that you're not there to find one of them right or wrong. The only thing they need to agree is the outcome. They don't need to agree on anything else. And that kind of sets the tone for the mediation. So that's why preparation is key. And what Ishara is describing can all be avoided if you follow these pre-steps. So Ishara, to answer your question, yes, I think it's an important role of the mediator to work with the parties beforehand, get them to understand what mediation is about, what you're trying to achieve, and how best they can approach it to get the most constructive outcome. Okay, Esther's complaining that my sound is soft. I'll try and move a bit closer and talk a bit louder, Esther. Okay, so all of that before the mediation. After the mediation, there's a number of possible ways that the mediation can end. The one we're all hoping for is that you conclude a settlement agreement. As we know, any agreement reached in mediation is non-binding until it's reduced to writing and signed by the parties. And I'll come back to deal with settlement agreements in a bit more detail once we've gone through all the possible outcomes. So if you've managed to agree it'll be reduced to writing and signed by the parties. And you need to consider whether the agreement needs to be made a court order, and I'll deal with that when I talk about settlement agreements. Another possible outcome is that you only partially settle, that you agree on some of the issues, but not others. And in all of these other cases, you need to be careful how you conclude the mediation. So where there's a partial settlement, there needs to be some kind of an agreement or discussion between the parties on whether the mediation on the other issues is suspended to be returned to at another date, or whether those other issues are now going to be referred for arbitration or follow the litigation process. So don't neglect to deal with that. If there's only some issues being resolved, don't leave the unresolved issues hanging. Have a discussion about whether you're going to come back to mediation on those, or whether they're going to go for adjudication in some form or another. Offers left hanging is also an interesting one and often a neglected one. As we know, mediation is a confidential process, and nothing said in the mediation can be referred to outside of the process. If one participant wants to leave an offer open for acceptance after the mediation concludes, it's important that that's then reduced to writing and specific expression given to that to survive the mediation. So just give some thought to that, like the partial settlement and the unresolved issues. If their offer's left hanging and they still want to be open for consideration, just record that in writing so that both parties are protected. Of course, one of the possibilities is that there's no settlement, the matters remain unresolved. Again, have a discussion with the parties about what the next steps are. Always leave the door open to returning to mediation. Parties can come back to the mediation table at any stage. And yeah, so leave that door open, but if there's no settlement, then the mediation concludes and the parties can go on their way. Important in that scenario to remind the parties of the confidentiality, that everything that was said there was without prejudice, and if the matter proceeds in a litigious forum, nothing that's been said at that process can be used. Sometimes the parties may not be ready to settle. You may start a mediation and you need further documentation, or you need a financial analysis done, or you need valuations done. In those circumstances, the mediation can be postponed to another date, and you can reconvene when you have everything that you need. It's important to manage that kind of a process, because you don't want to lose the momentum and the rapport and everything that you've built up. So yeah, you just wrap up that process in a way that reminds the parties of what's important, and then when you start again, recreate that space for collaboration. You will have seen in most mediation agreements that the mediator retains a right to terminate the process at any stage. If the mediator feels that it's not a conducive space anymore, it's really used, but the mediator reserves the right to terminate at any stage. And of course, the parties are entitled to withdraw at any stage if they feel like the process is not working for them. Mediator follow-up. So where some progress has been made, but there's perhaps no settlement, it's a good strategy to follow up with the parties. Even if you do settle, it's a good strategy to follow up with the parties, check in with them, see how they're doing, and seeing if you can assist in any way. And then reconvene the mediation. That will follow on a postponement, or if there's been partial settlement and the parties then want to come back on other issues. again, important to recreate that space. So again, the mediator's opening statement, probably in the reconvene mediation, is as important as before, just to set the tone again and bring the parties back into that mindset. So a number of ways that the mediation can finish. We're going to go back now to look at settlement agreements in a bit more detail, because again, there's a lot of thought that needs to go into these. So obviously the first thing, or the most important thing for the settlement agreement to record, is the terms of the settlement, and just check that they're clear, they're specific, and that they're time-based, and test enforceability. A good check is always, can the settlement be made an order of court? Will it be enforceable? Will the terms of this agreement be enforceable by a court? Make sure that it's concise and clear and realistic and enforceable. Deal with court processes and legal proceedings. So important in the settlement agreement to consider the context for the matter coming to mediation. If there are legal proceedings that have been suspended, deal in the agreement what happens. Is the plaintiff going to withdraw the claim, or is the agreement going to be made an order of court and the matter finalized at court? Just consider how those legal proceedings are going to be dealt with. Also consider who's going to be responsible for the legal costs. Obviously, costs have been incurred in that litigious process, and put that into the agreement. So again, make sure that all of those things are included. You can also include a breach clause. So if the agreement's not going to be made an order of court, then consider putting in a clause that deals with non-performance or non-payment in terms of the agreement and what's going to happen. Confidentiality clause, also very important, because outside of the mediation, once it's concluded, things are no longer confidential. So important that you specify that the agreement and the terms thereof remain confidential between the parties and may not be discussed. Some people also like to include a non-disparagement clause. In other words, that both parties agree not to badmouth the other. This is often used in employment disputes where they're disgruntled employees or disgruntled employers, that both parties agree not to speak badly of the other. Consider the mediation costs. Who's going to pay the cost of the mediation? That should be included in the agreement. Any tax implications if there's going to be payment of compensation. And then practical issues like returning company goods or handing back cell phones, returning laptops, all of those kinds of things. So a lot of thought needs to go into settlement agreements, and probably a good idea to have a template one that you use that covers all these issues, so that when you focused on kind of concluding a mediation, you don't lose sight of other issues that may end up having unintended consequences. Also, always include, and this can be part of the breach clause, a mediation clause. So in other words, if there is a breach of the agreement, or if any dispute arises, the parties come back to the mediation table. So, so really, just to wrap up, what we've spoken about is all the things that you can do before, or should do before, to make sure you have an effective mediation, and then make sure that the loose ends are all tied up properly. You've held the space until it's over, and you continue to hold that space for the parties to come back to if they need to. And hopefully then you would have had a constructive, positive process that parties will look back on and be satisfied with. So that really concludes the presentation. There's some very experienced mediators on here, so I would invite comments or discussion or questions from any of you on specifically these aspects, maybe experiences you've had where parties have been ill prepared, or where you failed to conclude something in a settlement agreement that you should have, and it's come back to bite you. Any of you had these kinds of experiences? Shara.
Thanks, Michelle. I had an experience last week, which was my first. And you mentioned today that a mediator can terminate the session. I actually was not aware that we could do that. But I was very, very tempted to. So we had spent a day in mediation and made a lot of headway. And when the person who raised the dispute found that he was gaining traction and his what he wanted at the outset was being, agreed to, he began to shift his position quite drastically, now wanting more, thinking that because it's now easy and because we have negotiated, I can possibly squeeze a little more out of this, which I know is wrong for me as a mediator to get upset about, but I actually did. I felt that we had spent the whole day, we had done so well. There was bona fides and amenability to stretching themselves, and then suddenly towards the end, he just began to demand stuff that was outside of the dispute. Any comments on that? Because I had to take a step back, take a breath, and calm myself down. Have you had a similar experience?
Yeah, so that's an interesting one, because you can get frustrated, and I think your response was right. We do have to take a deep breath and take a step back. What you could do in your opening statement, your mediator's opening statement, is say up front, if at any stage I feel like you're no longer participating in good faith, I reserve the right to terminate this. And then perhaps take the party aside and say, look, what you're doing now appears to no longer be, in good faith. I'm considering terminating unless you rein it in, kind of thing. Yeah. So I think if you set those ground rules up front, then you're in a position to say, look, I said in the beginning, if I felt you weren't participating in good faith, what is going on with you? What are you actually trying to achieve? Yeah. And if you continue in this vein, I'm going to terminate because I think you're taking advantage. Yeah. Okay, thank you. Yeah, but important, we're in control. As mediators, you're in control, and you need to, to be in charge of that process.
Sure, thanks.
Yeah. Anybody else? Any questions or comments or experiences you've had?
Maybe if I can add to that, Michelle, Ishara, just to add to what Michelle has just said now, yes, we can terminate the process as well, which is part of your mediation agreement. And what I say to my clients is, I'm fortunate enough to have my practice at home. So I always say, when you need to take a breather, or if I need to take a breather, just go out of the office, walk around the garden, have a smoke, kick the ball for my dog, stick your feet in the pool, and then you come back and we go further, because you only can tolerate so much. And then you can come back and we're human. So keep it human. And if you need to take a breather, because that will also make him rethink, yeah, did I just take the mickey out of this thing now? And then he'll come back and he'll say, okay, maybe I pushed the envelope too far now. And then he'll back off.
Mohammed, you're one of the more experienced mediators. Anything to add?
Michelle, yes, I would. I think of late what I've been doing is that I have the intake session, very short, because in advance when the attorneys are referring, we send the agreements out. But what I find very useful is I cite caucus from the get-go. And I find that we achieve quite a bit like that. And I think also with advocating of mediation, the attorneys that are referring the clients to us are, some will attend, but many are not attending with their clients, which is a good thing. because then they sort of trust you as the mediator and the process. But I find it very, very useful to side caucus from the beginning. It just works well.
What do you do in that side caucus, Mohammed, initially?
Say again?
In that side caucus, what do you do initially? Is it just to
I just run the process parallel. I have two boardrooms, and they're not next to each other. They're like on two wings of my office. I've moved up to another office. Some of you may, but I just shuttle between the two, and it works well because we make a lot more progress. And, you know, as opposed to, I remember in the early days when I used to have the parties together all the, you know, like for most of the time, I thought, you know, when I look back, it's very idealistic that they're going to speak freely. And, you know, I think even a mind shift as a mediator is from trying to fix the world and sort the problems out now by putting them separately. And it works like that. I just feel there's a lot more to gain. The process is more productive like that. Exactly, Ishara, I agree with you.
So Ishara has posted in the chat, she does the same. It builds rapport and instills confidence. It's exhausting though. Yes, it is exhausting. And I think it's important for us to manage ourselves. Often you shuttling between the two and you don't take a break yourself, and you end up feeling very depleted at the end of the day. So a little bit of discipline on our part is also needed there, because it mediating takes a lot out of you to hold that space, and to, especially when you're shuttling between two parties, you've got to have your radar on full alert all the time about what you're disclosing to the other side, and if you have permission to disclose, you're dealing with a lot. So yes, very important to keep your own sanity preserved during the process. Anything else?
Can I ask a question, please, Michelle?
Of course, go ahead, Issa.
I just want to ask you whether you're going to, when one can get your recording, because I couldn't hear you. I just look at your notes. I don't know what went wrong there, and thank you for that. What is your advice when a client is breaking the contract agreement? And after you back went to another person, another mediator, what is the process you follow, the correct way?
Let me understand you correctly. So you've concluded a settlement agreement or an agreement to mediate?
The agreement, before I even start, as you said, you have the introduction first, and then I've got a contract, you know, like a mediation agreement. And they must sign that thing, and then you can go ahead. Right. Now, if one of the parties then behind your back go to another party, with other words, that she is then in a breach of contract, what is your advice? How did you deal with that?
They've gone to another attorney or another mediator? Another
mediator. But they didn't inform the other party as well. They did it behind the back of myself and the other party involved.
Yeah. So look, one of the principles of mediation is that you can withdraw at any stage if you're not happy with the process. So I suppose what they did wrong here was they didn't do it formally and transparently. Because if they had just said to you, I'm withdrawing from this process, I don't want to participate anymore, you know, there's nothing you can do. You have to honor that. But yeah, I suppose I would just phone that, get in touch with that other party, and just ask, you know, what's going on? Why have they terminated this particular mediation? Yeah, I would perhaps try and get the mediation back on track and try and understand what precipitated this conduct. And if they don't want to participate, as I said, there's nothing you can do. You have to release them, and then the other client would have to be drawn into the other mediation process by consent. But that's an unusual situation, Esther.
Thank-
How did you handle it? Ishara's also got some input.
Yes, no. You know, I'm not very fond of WhatsApp messages. I feel always it must be professionally done in email format or an appointment. That's how I deal. So I call her in, but she just told me, no, she's not interested in me anymore. And being a social worker as well, so you're in breach of contract with the ethical code. So it was very ugly, but you know, I try to keep myself professional, and also you can't go ahead unbiased anymore. So I then withdraw, and I've got an appointment to this afternoon for her to come and cancel the contract and hand over then my letter on my letterhead that she cancel a contract, and whoever is taking over, I am still in charge with the other party also going ahead. The other partner.
Okay.
But you can't do that, not as mediator. If you are no longer a mediator to the process, you need to totally withdraw, and then the parties need to move forward with a new mediator, and both parties then need to, by consent, agree to mediate with a new person.
Yeah.
You can no longer act for either of the parties.
No, I
Yes,
don't.
yes.
No.
If I can just come in, what I just want to add, what I normally do at the outset of the mediation, getting to know the parties and the dispute, is I ask them if there have been previous attempts at settlement, whether it is a negotiation or a mediation, etc., just to avoid this kind of. So that's a good practice, so that hopefully the new mediator that comes in will also pose that question, and they may say, well, we were with Esther and we then abandoned it, etc.
And the correct procedure to follow is to do, I think it is a Form 10 that you issue as the mediator to say what was the outcome of the mediation. If it is a family mediation, just to say mediation was terminated, and you can just say party X terminated. You don't need to give the reasons for it, but then as the mediator, you can no longer be involved in the matter. You need to step back, and then that's the end of it.
Yeah.
Deanne, may I just ask you, what about the carrying on the party, because you're a social worker as well, and do assistance?
No, you're not allowed to.
Okay.
So just perhaps, Esther, so were you social worker as mediator, mediating between the two parties?
They were. Sorry, Michelle, it's a very difficult case here. They're not married. And there's a third party involved now. And there's a child of 5 years.
But your role, was it as social worker or as mediator?
It was first social worker because of counseling them, and then they said they have to get a parenting plan in place between the two.
Okay, so then you stepped into the role of mediator. Okay, and then Jeanne, so what you're saying is that she can't go back to that role of social worker. She has to withdraw completely from the matter. Is that right?
Yeah, that would be the more ethical approach.
Okay. Okay, if there are no more questions, comments, discussions, I think let's wrap up. So thank you all for your time this afternoon. I hope you found this of some benefit. The recording will go up onto our website, and Shelley can circulate the slides for those of you that would like a copy of them. And then watch the space on the website for the next webinar, which will be in about 4 to 6 weeks' time. So thank you very much, everybody, and I wish you a good afternoon.
Thank you, Michelle.
Thank you, Michelle. Much appreciated. Take care, guys. Bye.
Michelle, keep well.
Bye.
Thank you, Michelle.
Welcome.